The third case that I wanted to talk about is a case that involves a potential battle of jurisdictions. So the scenario is you have a company here in Denmark which has a contract with a company somewhere in the United States, and there's a contract which maybe not provides for all disputes to be resolved in the U.S. And this U.S. counterpart, which in my case was the bigger party in this fight, was sort of trying to steamroll the Danish client. And if they were successful in either just choking him or running him out of gas, or in that process filing a U.S. lawsuit that he would have to go through, there was no way the client was going to survive that. So we realized that if we were going to stand a chance of reaching some sort of a reasonable result for the client in this dispute, we would have to take the fight to home court, so to speak. Because, as we all know, at least the sports fans, that is a major advantage. So, and the way we actually achieved that was to make sure that we filed a lawsuit at a time when there was jurisdiction under Danish law. The problem here, and this is very technical, but the problem being that if all you have against your U.S. counterpart is a monetary claim, there probably will not be jurisdiction in Denmark under the Danish rules. What we did was we filed a lawsuit immediately at a time when, under the contract, which had not at that point been terminated, there were obligations for the U.S. counterpart that arguably were not monetary. They were obligations that were, so to speak, specific, that we could require that they perform specific obligations in Denmark. And if that's the case, then under Danish law, there would be jurisdiction in Denmark. So the combination of filing it at a time when you could actually ask for specific performance of non-monetary obligations, and the fact that we could reasonably attack a clumsily worded jurisdictional clause in the contract, made it possible for us to get a case in Danish court. And once we achieved that, the U.S. party was dragged to the negotiating table, and it was possible to find settlement. Had we been dragged to the United States, we would have never been able to settle. The client would have lost without a doubt.